Section 6. Disinheritance. Article 915. A compulsory heir may, in consequence of disinheritance, be deprived of his legitime for causes expressly stated by law. Article 916. Disinheritance can be effected only through a will wherein the legal cause therefore shall be specified. Article 917. The burden of proving the truth of the cause for disinheritance shall rest upon the other heirs of the testator, if the disinherited heir should deny it. Article 918. Disinheritance without a specification of the cause, or for a cause the truth of which, if contradicted, is not proved, or which is not one of those set forth in this code, shall annul the institution of heirs in so far as it may prejudice the person disinherited, but the devises and legacies and other testamentary dispositions shall be valid to such extent as will not impair the legitime. Article 919. The following shall be sufficient causes for the disinheritance of children and descendants, legitimate as well as illegitimate. 1. When a child or descendant has been found guilty of an attempt against the life of the testator, his or her spouse, descendants, or ascendants. 2. When a child or descendant has accused the testator of a crime for which the law prescribes imprisonment for 6 years or more, if the accusation has been found groundless. 3. When a child or descendant has been convicted of adultery or concubinage with the spouse of the testator. 4. When a child or descendant by fraud, violence, intimidation, or undue influence causes the testator to make a will or to change one already made. 5. A refusal without justifiable cause to support the parent or ascendant who disinherits such child or descendant. 6. Maltreatment of the testator by word or by deed by the child or descendant. 7th, when a child or descendant leads a dishonorable or disgraceful life. 8. Conviction of a crime which carries with it the penalty of civil interdiction. Article 920. The following shall be sufficient causes for the disinheritance of parents or ascendants, whether legitimate or illegitimate. 1. When the parents have abandoned their children or induced their daughters to live a corrupt or immoral life or attempted against their virtue. 2. When the parent or ascendant has been convicted of an attempt against the life of the testator, his or her spouse, descendants, or ascendants. 3. When the parent or ascendant has accused the testator of a crime for which the law prescribes imprisonment for 6 years or more, if the accusation has been found to be false. 4th, when the parent or ascendant has been convicted of adultery or concubinage with spouse of the testator. 5th, when the parent or ascendant by fraud, violence, intimidation, or undue influence causes the testator to make a will or to change one already made. 6. The loss of parental authority for causes specified in this code. 7th, the refusal to support the children or descendant without justifiable cause. And 8. An attempt by one of the parents against the life of the other, unless there has been a reconciliation between them. Article 921. The following shall be sufficient causes for disinheriting a spouse. 1. When the spouse has been convicted of an attempt against the life of the testator, his or her descendants, or ascendants. 2. When the spouse has accused the testator for a crime of which the law prescribes imprisonment for 6 years or more and the accusation has been found to be false. 3. When the spouse by fraud, violence, intimidation, or undue influence causes the testator to make a will or to change one already made. 4th, when the spouse has given cause for legal separation. 5th, when the spouse has given grounds for the loss of parental authority. And 6th, unjustifiable refusal to support the children or the other spouse. Article 922. A subsequent reconciliation between the offender and the offended person deprives the latter of the right to disinherit and renders ineffectual any disinheritance that may have been made. Article 923. The children and descendants of the person disinherited shall take his or her place and shall preserve the rights of compulsory heirs with respect to the legitime, but the disinherited parent shall not have the usufruct or administration of the property which constitutes the legitime. Section 7. Legacies and Devises. Article 924. All things and rights which are within the commerce of man may be bequeathed or devised. Article 925, a testator may charge with legacies and devises not only his compulsory heirs but also legacies and devises. The latter shall be liable for the charge only to the extent of the value of the legacy or the devise received by them. The compulsory heirs shall not be liable for the charge beyond the amount of the free portion given them. Article 926. When the testator charges one of the heirs with a legacy or devise, he alone shall be bound. Should he not charge anyone in particular, all shall be liable in the same proportion in which they may inherit. Article 927. If two or more heirs take possession of the estate, they shall be solidarily liable for the loss or destruction of a thing devised or bequeathed, even though only one of them should have been negligent. Article 928. The heir who is bound to deliver the legacy or devise shall be liable in case of eviction if the thing is indeterminate and is indicated only by its kind. Article 929. If the testator, heir, or legatee owns only a part of or an interest in the thing bequeathed, the legacy or devise shall be understood limited to such part or interest unless the testator expressly declares that he gives the thing in its entirety. Article 930. The legacy or devise of a thing belonging to another person is void if the testator erroneously believed that the thing pertained to him. But if the thing bequeathed, though not belonging to the testator when he made the will, afterwards becomes his by whatever title, the disposition shall take effect. Article 931. If the testator orders that the thing belonging to another be acquired in order that it be given to a legatee or devise, the heir upon whom the obligation is imposed or the estate must acquire it and give the same to the legatee or devise. But if the owner of the thing refuses to alienate the same or demands an excessive price therefor, the heir or the estate shall only be obliged to give the just value of the thing. Article 932. The legacy or devise of a thing which at the time of the execution of the will already belonged to the legatee or devise shall be ineffective even though another person may have interest therein. If the testator expressly orders that the thing be freed from such interest or encumbrance, the legacy or devise shall be valid to that extent. Article 933. If the thing bequeathed belong to the legatee or devise at the time of the execution of the will, the legacy or devise shall be without effect, even though it may have been subsequently alienated by him. If the legatee or devise acquires it gratuitously after such time, he can claim nothing by virtue of the legacy or devise, but if it has been acquired by onerous title, he can demand reimbursement from the heir of the estate. Article 934. If the testator should bequeath or devise something pledged or mortgaged to secure irrecoverable debt before the execution of the will, the estate is obliged to pay the debt unless the contrary intention appears. The same rule applies when the thing is pledged or mortgaged after the execution of the will. Any other charge, perpetual or temporary, with which the thing bequeathed is burdened, passes with it to the legatee or devise. Article 935. The legacy of a credit against a third person or of the remission or release of a debt of the legatee shall be effective only as regards that part of the credit or debt existing at the time of the death of the testator. In the first case, the estate shall comply with the legacy by assigning to the legatee all rights of action it may have against the debtor. In the second case, by giving the legatee an acquittance should he request one. In both cases, the legacy shall comprise all interests on the credit or debt which may be due the testator at the time of his death. Article 936. The legacy referred to in the preceding article shall lapse if the testator, after having made it, should bring an action against the debtor for the payment of his debt, even if such payment should not have been effected at the time of his death. The legacy to the debtor of the thing pledged by him is understood to discharge only the right of pledge. Article 937. A generic legacy of release or remission of debts comprises those existing at the time of the execution of the will but not subsequent ones. Article 938. A legacy or devise made to a creditor shall not be applied to his credit unless the testator so expressly declares. In the latter case, the creditor shall have the right to collect the excess, if any, of the credit or of the legacy or devise. Article 939, if the testator orders the payment of what he believes he owes but does not in fact owe, the disposition shall be considered as not written. If as regards a specified debt more than the amount thereof is ordered paid, the excess is not due unless a contrary intention appears. The foregoing provisions are without prejudice to the fulfillment of natural obligations. Article 940, in alternative legacies or devises, the choice is presumed to be left to the heir upon whom the obligation to give the legacy or devise may be imposed, or the executor or administrator of the estate if no particular heir is so obliged. If the heir legatee or devise who may have been given the choice dies before making it, this right shall pass to the respective heirs. Once made, the choice is irrevocable. In alternative legacies or devises, except as herein provided, the provisions of this code regulating obligations of the same kind shall be observed, save such modifications as may appear from the intention expressed by the testator. Article 941, a legacy of generic personal property shall be valid even if there be no things of the same kind in the estate. A devise of indeterminate real property shall be valid only if there be immovable property of its kind in the estate. The right of choice shall belong to the executor or administrator who shall comply with the legacy by the delivery of a thing which is neither of inferior nor of superior quality. Article 942, whenever the testator expressly leaves the right of choice to the heir or to the legatee or to the devise, the former may give or the latter may choose whichever he may prefer. Article 943. If the heir, legatee, or devise cannot make the choice, in case it has been granted him, his right shall pass to his heirs, but a choice once made shall be irrevocable. Article 944, a legacy for education lasts until the legatee is of age, or beyond the age of majority, in order that the legatee may finish some professional, vocational, or general course, provided he pursues his course diligently. A legacy for support lasts during the lifetime of the legatee if the testator has not otherwise provided. If the testator has not fixed the amount of such legacies, it shall be fixed in accordance with the social standing and the circumstances of the legatee and the value of the estate. If the testator during his lifetime used to give the legatee a certain sum of money or other things by way of support, the same amount shall be deemed bequeathed, unless it be markedly disproportionate to the value of the estate. Article 945. If a periodical pension or a certain annual, monthly, or weekly amount is bequeathed, the legatee may petition the court for the first installment upon the death of the testator and for the following ones, which shall be due at the beginning of each period. Such payment shall not be returned even though the legatee should die before the expiration of the period which has commenced. Article 946. If the thing bequeathed should be subject to a usufruct, the legatee or devise shall respect such right until it is legally extinguished. Article 947. The legatee or devise acquires a right to the pure and simple legacies or devises from the death of the testator and transmits it to his heirs. Article 948. If the legacy or devise is of a specific and determinate thing pertaining to the testator, the legatee or devise acquires the ownership thereof upon the death of the testator, as well as any growing fruits or unborn offspring of animals or uncollected income, but not the income which was due and unpaid before the latter's death. From the moment of the testator's death, the thing bequeathed shall be at the risk of the legatee or devise, who shall therefore bear its loss or deterioration, and shall be benefited by its increase or improvement, without prejudice to the responsibility of the executor or administrator. Article 949. If the bequest should not be of a specific and determinate thing, but is generic or of quantity, and its fruits and interests from the time of the death of the testator shall pertain to the legatee or devise if the testator has expressly so ordered. Article 950. If the estate should not be sufficient to cover all the legacies or devises, their payment shall be made in the following order. 1. Remuneratory legacies or devises. 2. Legacies or devises declared by the testator to be preferential. 3rd, legacies for support. 4th, legacies for education. 5th, legacies or devises of a specific determinate thing which forms a part of the estate. And 6th, all others pro rata. Article 951. The thing bequeathed shall be delivered with all its accessions and accessories and in the condition in which it may be upon the death of the testator. Article 952. The heir charged with the legacy or devise or the executor or administrator of the estate must deliver the very thing bequeathed if he is able to do so and cannot discharge this obligation by paying its value. Legacies of money must be paid in cash even though the heir of the estate may not have any. The expenses necessary for the delivery of the thing bequeathed shall be for the account of the heir or the estate, but without prejudice to the legitim. Article 953. The legatee or devise cannot take possession of the thing bequeathed upon his own authority, but shall request its delivery and possession of the heir charged with the legacy or devise or of the executor administrator of the estate, should he be authorized by the court to deliver it. Article 954. The legatee or devise cannot accept a part of the legacy or devise and repudiate the other if the latter be onerous. Should he die before having accepted the legacy or devise, leaving several heirs, some of the latter may accept and the others may repudiate this share respectively belonging to them in the legacy or devise. Article 955. The legatee or devise of two legacies or devises, one of which is onerous, cannot renounce the onerous one and accept the other. If both are onerous or gratuitous, he shall be free to accept or renounce both or to renounce either. But if the testator intended that the two legacies or devises should be inseparable from each other, the legatee or devise must either accept or renounce both. Any compulsory heir who is at the time a legatee or devise may waive the inheritance and accept the legacy or devise, or renounce the latter and accept the former, or waive or accept both. Article 956. If the legatee or devise cannot or is unwilling to accept the legacy or devise, or if the legacy or devise for any reason should become ineffective, it shall be merged into the mass of the estate, except in cases of substitution and of the right of accretion. Article 957. The legacy or devise shall be without effect. 1. If the testator transforms the thing bequeathed in such a manner that it does not retain either the form or the denomination it had. 2. If the testator by any title or for any cause alienates the thing bequeathed or any part thereof, it being understood that in the latter case the legacy or devise shall be without effect only with respect to the part thus alienated. If after the alienation the thing should again belong to the testator, even it be by reason of nullity of the contract, the legacy or devise shall not thereafter be valid, unless the reacquisition shall have been effected by virtue of the exercise of the right of repurchase. 3. If the thing bequeathed is totally lost during the lifetime of the testator or after his death without the heir's fault, nevertheless the person obliged to pay the legacy or devise shall be liable for eviction if the thing bequeathed should not have been determinate as to its kind in accordance with the provisions of Article 928. Article 958. A mistake as to the name of the thing bequeathed or devised is of no consequence, if it is possible to identify the thing which the testator intended to bequeath or devise. Article 959. A disposition made in general terms in favor of the testator's relatives shall be understood to be in favor of those nearest in degree.